Can you hear us?
Yes.
Can you see us?
Yes.
Okay, great. Well, I appreciate your patience. We had a little bit of glitch here right before we were ready to start. We had a power outage, so we appreciate Paul and Tom working their magic to get us up and going again. So, my name is John Rogers. I'm the Associate Director of the Division of Oil, Gas, and Mining, and I've been asked by the boards of Oil, Gas, and Mining to act as a hearing officer in this matter. It is June 20th, 2018, and we are assembled in the Department of Natural Resource Building in Salt Lake City. The matter that we are going to hear today is a request for agency action by AXIA Energy 2, LLC for order pulling all interests, including the compulsory pulling of the interests of certain non-consenting and unlocatable owners within 3 1280-acre drilling units or substantial equivalents established for the production of oil and gas and associated hydrocarbons from the Lower Green River-Wasatch Colton formations, comprised of all sections of 14 and 23 of Township 2 South, Range 2 West of the U.S. Special Meridian, Duchesne County, and sections 27 and 28 and 35 and 36 of Township 2 South, Range 3 West, U.S. Special Meridian, Duchesne County. I am being represented by Emma Whitaker of the Utah Attorney General's Office, and legal counsel for AXIA is present in the room today, but we will be hearing from AXIA via video conferencing. We now can take appearance of counsel.
David Bolda with Beatty and Wozniak on behalf of AXIA Energy 2 LLC.
Meg Oswald, Utah Attorney General's Office on behalf of the Division of Oil, Gas, and Mining.
Okay, thank you. Mr. Bolda, do you have witnesses you would like to present?
Yes, I'd like to introduce those witnesses, and then I'll take care of a few housekeeping things and then give a summary. Appearing from Highlands Ranch, Colorado, I have Rick Gallegos, the Vice President of Land and Business Development, Leslie Gadd, who is a Senior Landman for AXIA, and Taryn Frenzel, the Vice President of Completions and Engineering. And if it's acceptable to you, I'd like to have them sworn in at this time, all three of them.
Do you intend to have them be expert witnesses?
Just Mr. Frenzel, the engineering portion.
Division, would you like to have him review his qualifications, or would you accept him?
I think we would just like to get him on the record, but we will accept them, and we can do it right before his testimony, if that's okay.
Okay.
Yeah, that was the plan. We'll go over his qualifications, and when we get to him, he'll be the very last witness today.
Okay. All right, we'll have him sworn in then.
Will you raise your right hands, please? You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Mr. Bolda, we'll turn the time over to you.
Okay, thank you. So a couple of housekeeping matters. First, I wanted to confirm that everybody received the motion for leave with the attached exhibits that were filed yesterday, and that there was an order that was signed by the chairman as well. I want to make sure everybody got those. And then there was another change that we made to one of the exhibits. One of the parties to be pooled ended up signing a JOA, so we removed them, and that's what the second amended Exhibit 3 is, and it's probably in that pile there somewhere.
Okay, I have.
Okay.
This one here.
There we go. Also, AXIA on May 18th, we filed a letter to the board explaining that at this hearing today that we would move to amend the requested relief in the hearing, whereas the original request for agency action asked that an order granting AXIA's request apply to subsequent wells drilled within a drilling unit. In the letter we stated that we were going to drop that from our request so that it would only apply to each of these 3 wells that are the subject of this request today.
Okay.
So I just wanted to let you know that we're no longer requesting that it apply to subsequent wells.
And Division, were you aware of that change?
Yes, and we don't have any, I mean, we essentially requested that change, so that is good with us. And then I think I had just a point of clarification on the change, which was that the request also states that AXIA would be declared operator of the entire drilling unit. And so I think with that change, it would be that AXIA would be operator of the wells.
Yes, that's correct.
Okay, great.
Okay. All right, I will now give a summary here, and then we'll get to our witnesses. So subject sections 14 and 23 of Township 2 South, 2 West were established as a 1,280-acre stand-up drilling unit in cause number 139-149, entered on March 21st, 2018, for Lower Green River-Wasatch production. Subject sections 27 and 28 and 35 and 36 of 2 South, 3 West were established as laydown 1,280-acre drilling units in cause number 139-140, entered on January 23rd, 2017, as modified by the order on rehearing for modification entered on April 4th, 2017, again for Lower Green River-Wasatch production. True and correct copies of those orders, the 139-149 and 139-40 orders, were submitted as Exhibit B. We won't be covering those today, but they've been submitted as exhibits. There are 3 wells for which compulsory pooling is sought today. And you'll hear in the testimony that there are some unleased interest owners who have been unlocatable. There are also a few estates of deceased parties for whom forced pooling is sought because probate hasn't been done, and we don't know if all the heirs have been leased or not until an order has been entered. As will be discussed during the testimony of Ms. Gadd, AXIA has diligently searched for the potential heirs of these deceased parties and obtained leases where they could be located. However, until those estates have been probated, there's no way to definitively determine who all of the heirs are. That is why we were asking that those interests be compulsory pooled in case additional heirs are discovered. In many cases, before official offer letters to lease or participate in the subject wells were sent via certified mail, AXIA commenced efforts to locate and lease the parties. So what we submitted as exhibits with the return receipts, those are in preparation for this hearing, but efforts began much sooner. AXIA has continued to work with and negotiate with any of the parties willing to lease their interest or participate in the subject wells throughout this process, even after filing this request. This is also illustrated by the motion for leave to file amended exhibits that was submitted yesterday and again last night, that they were continuing to work with parties to lease or participate. Since there are various BLM and BIA tracks involved, communitization agreement will be required to pool their interests and create a pro-ration unit to conform with the board's orders in 139-149 and 139-40. However, that communitization agreement will not be approved until a compulsory pooling order is entered. The testimony and evidence presented today will establish that the regulatory and statutory requirements have been satisfied to deem the unleased and uncommitted working interest owners as non-consenting parties and to compulsory pool their respective interests in the subject wells. We have asked that, or we have submitted as Exhibit G a proposed JOA, Joint Operating Agreement, to govern operations with the compulsory pooled parties. AXIA submitted one JOA to be used as a form for each of the 3 wells rather than 3 separate JOAs that contain all the same terms. That the testimony will establish that the JOA contains fair and reasonable terms. I want to point out that the board has jurisdiction over this matter pursuant to Utah Code annotated section 40-6-6.5. A copy of the request was mailed by certified mail to all interested parties within the subject sections and to the governmental agencies having supervisory jurisdiction. As evidenced by the return receipts collectively submitted as Exhibit ZZZ, as submitted yesterday, nearly all identifiable, locatable parties received a copy of the request. A couple of them, there's some status sheets saying they were delivered, but we just didn't get the receipt, the green card signed back yet. And then as to those parties who could not be located because no current valid address could be found, or are potential heirs or devisees of the estates of deceased parties, notice was published in the Uinta Basin Standard and utahlegals.com. As indicated on the affidavit of publication, that's marked as Exhibit YYY, and that was also submitted yesterday. Notice of the request and the hearing was also duly published in the Salt Lake Tribune and Deseret Morning News on June 3rd, 2018, and in the Uinta Basin Standard on June 5th, 2018. Only one response was received, and this response was from Hunt Oil Company, and that was on June 11th, 2018. Hunt Oil Company was originally included as a party to be pooled, but they had since executed a lease with AXIA. At the time they submitted their letter, they hadn't yet received payment for their lease, and so they filed a letter stating, or just making their appearance essentially in case they didn't get paid, and we were still seeking to compulsory pool their interest. We are no longer seeking to pool that interest since they've executed a lease, and so they have been removed from the amended exhibits. No other responses were received from any notice parties. And the division didn't file a staff memorandum. And then finally, I want to point out that there is one subcategory of an interest owner in this cause. It's a lessee that is elected to participate but is not signed a JOA. That is, there's actually 3 companies involved with the same principles, and that's Bro Energy LLC, International Petroleum Limited Liability Company, and then International Petroleum Exploration and Corporation. International Petroleum Exploration Corporation. I have spoken with their attorney. They haven't filed anything, any notice of appearance or objections in this cause, but I've spoken with their attorney, and they have agreed that they will allow the board to impose the terms of the JOA upon them, but they will be treated as all other consenting owners within the respective drilling units in which they own an interest. So they won't be assessed a penalty. It's just they haven't signed the JOA, and we're asking that the JOA be imposed upon them. And with agreement of their attorney, like I said, they're still considered parties to the request, but we'll have the terms of the JOA imposed upon them.
Just a point of clarification. So if they don't sign the JOA, or do you have a time frame of when they need to sign that by, which you would take them out?
Well, we're essentially taking them out. We have an agreement with them that they won't be treated as a compulsory pooled party. They won't be assessed a penalty. The terms of the JOA will be imposed upon them. So that was the agreement or understanding with their attorney prior to this hearing.
They have chosen not to be a working interest owner.
Well, they are a working interest owner. They've elected to participate. But they have their own reason for not signing the JOA, and they've, like I said, we're asking that it be imposed upon them. They understand that we're asking that, and they accept that. So, and again, they haven't filed a response.
Can I just, a clarifying question from
Yeah.
you too? So are they not on the amended exhibits just because you just figured this out? Or why, I guess, why are they still included on your list of parties you're seeking to compulsory pool?
Well, they are included because they have not signed the JOA.
But they're not, you're not asking to compulsory pool them?
We're just asking that the terms of the JOA be imposed upon them.
Okay.
Yeah.
And they will invest in this property, they will put dollars into it.
Yeah, they, like I said, they've elected to participate, so they've elected to pay their proportionate share. They just have a reason why they don't want to sign the JOA and instead have it imposed upon them.
I guess that issue is between you and
Yeah,
them.
it's a separate agreement. But.
It's between AXIA and them to an extent, but I think they're also asking for the board to impose a JOA. So that would be a decision that the board would have to make.
Right, so where the statute allows a party to propose a different JOA and have that imposed upon them, instead of proposing a different JOA, they've asked or they haven't asked, but we are asking, and by agreement, we're asking that the JOA that was submitted as Exhibit G be imposed upon them.
I guess the difficult thing I'm seeing, if you have a verbal agreement with them, but if they change their mind down the road, does that leave you in a difficult position, not having a signed document?
Well, there isn't that risk because the JOA is imposed upon them. They've elected to participate, so either way, they're going to share in the cost. They're going to pay their proportionate share, but the terms of the JOA that we submitted as exhibit, we're asking that govern the relationship between them, between AXIA and those three entities, Bro Energy.
And those three entities are essentially the same people?
The same principles are involved in those three. Yeah. Any other questions on that?
It's kind of unique.
Yeah, it is a little bit different, but that's the agreement that AXIA and those three entities reached, or the principles for those three entities reached. So we believe that's acceptable under the statute, that the terms can be imposed upon them, but they will not be subject to a penalty. Okay. Do you want me to, can I move on?
Yep.
Okay. Okay, and again, I want to reiterate, they didn't file a response. They knew what we were going to ask for at the hearing today. If they wanted to be heard, wanted something different, they could have filed a response. They could have appeared here, but this was the agreement that they reached. Okay, I would now like to turn to my first witness. And that is Leslie Gadd. Leslie, can you please state your name and business address for the record?
This is 1805 Shea Center Drive, Suite 400, Highlands Ranch, Colorado, 80129.
And can you please state your current position with AXIA?
Yes, I'm senior landman for the Uinta Basin area where these lands are located.
Okay, and as to AXIA's corporate and bonding status, can you please explain what that is?
AXIA is a Delaware limited liability company in good standing, and we are qualified to conduct business in the state of Utah. We're fully bonded and with the state of Utah and all the federal agencies.
Okay, thank you. Now, turning to Exhibit C, was this exhibit prepared by you or with your input and review?
Yes, it was.
Okay. Can you please explain this exhibit?
This exhibit is showing where the three requested forced pooling orders are located. and the cause numbers where the spacing was determined for those particular lands.
Okay, thank you. Leslie, I'd now like you to, I believe you have in front of you exhibits D, E, and F, and exhibits 7, 8, and 9. Since we'll be going to those exhibits, I'd like to ask you if those were prepared by you or with your input and review.
Yes, they were.
Okay, we'll go first to exhibit D, and exhibits 7, 8, and 9, to clarify, are exhibits to the request. They were filed with the request, and she'll explain what those exhibits are. So we'll first turn to exhibit D.
Okay.
And can you please explain this exhibit, Leslie?
Sure. Exhibit D is a plat of the lands that we're asking to be pooled. Each tract within these lands has different ownership, which is why they're set out as different tracts. And then there is the survey of where the actual well is located, with a surface hole location as well as the bottom hole location.
Okay, and then exhibit
Want me to go
7?
on to 7?
Yes, please.
Okay, so then exhibit 7 is rather than a map, sets out each tract that you see on the map, how many gross acres within the 1,280 pooled unit, the percent of the unit, and who owns it, whether it's fee. In this particular case, there's all fee except for tracts 8, 10, and 11. Those are the state of Utah and the University of Utah own those.
Okay.
Right.
We will go now to exhibit E. Can you explain this exhibit?
Same as the last one, where exhibit E is showing you a visual of all the different tracts with different ownerships again, that comprise the entire 1,280 pooled unit that we're requesting. And again, the survey was showing the surface hole location and the bottom hole location that's traversing these lands. And then exhibit 8 gets you down to the exact gross acres that each tract is contributing, the percent of the unit, and the ownership, again, all of them being fee ownership, except there's a lot of tracts, so hang on here. Tract 28, Duchesne County School District, and, I'm sorry, tract 33, and is Duchesne County School District. 34 is federal and fee. And the last tract, 46, is Duchesne County. The rest are all fee tracts.
Okay, thank you. Now on to exhibit F.
Okay. Exhibit F, again, is showing the lands that we're asking to be pooled for sections 35 and 36, 2 south, 3 west. The survey for that showing the surface hole location, bottom hole location. And then exhibit 9 sets out the gross acres in each one of those tracts, the percent of the unit that each tract makes up. And then here we've got some BIA allotment leases in tracts 7 and 8, and Department of Transportation in tract 14. And the rest are all fee tracts.
Okay, thank you. Now, on those exhibits, can you please explain how those tracts were determined and how individual ownership within the subject sections were determined?
Sure. So we hire a title attorney who researches the county records, the federal records, the BIA records, to determine ownership in each tract. And from that title opinion, we get these exhibits where we can identify who are the owners, whether they're fee, whether they're state, whether they're BIA, and that's how we end up comprising particularly these like exhibit 9s, where we have the exact tract and the percent that each one owns. And it's through those title opinions we receive from our attorneys that we are able to determine who owns what and in what lands.
Okay, and do you know when those title opinions were rendered relating to these 3 drilling units?
Not off the top of my head, David. I don't have dates off the top of my head. I'm sorry.
Okay, I have that they were rendered for AXIA between June 3rd, 2016 and March 22nd of 2018. Is that correct?
Yeah. Yes.
Okay. And then were these records updated by yourself or AXIA personnel prior to this hearing?
Yes, they were.
Okay. They're a search of the county records, correct?
Correct.
Okay, thank you. I'd now, Leslie, like you to turn to amended Exhibits 1 and 2, second amended Exhibit 3, and Exhibits 4, 5, and 6 to the request, and ask if these were prepared by you or with your input and review.
Yes, they were.
Thank you. Let's turn now to, actually, but before we get to those, I forgot, we filed a demonstrative exhibit that kind of explains and puts together what those amended Exhibits 1 through 3 and Exhibits 4 through 6 show. So this is a breakdown. So we'll go to this first. Leslie, demonstrative Exhibit 1. Can you explain what this exhibit shows here?
Yes, this might make things a little bit clearer because I have to tell you these exhibits like 1, 2, and 3, they can be pretty complex, and if you see how many owners are listed, it sometimes looks startling, but when you look at percent of ownership that's unleased, for example, or where no one's made an election, it's maybe not quite as startling. So, for example, in our drilling unit 1, which is amended Exhibit 1, we originally started with 36 unleased interests, of which we have 23 remaining. So you'll see up there that the total amount of interest for those that are unleased and unlocatable is less than 1%. The total amount of those that are unleased and locatable is 3%. And then we have the total interest of voluntary pools where they signed out JOA. I know it says up there 93.25141%, but literally we just received a text that Bowers Oil and Gas has signed the JOA at 10:20 a.m. today, which is an additional 1.203161%. So we'll be removing them before the end of all this in that particular drilling unit. And then in drilling unit 2, excuse me, there were 30 original unleased. We now have 17 unleased. Of the ones that are unleased and unlocatable, it's just over 0.5%. Then those that are unleased and locatable, there are 10 individuals that are showing up on here, or 10 lines, I should say, of unlocatable people. However, I've been doing an awful lot of research, and one of the entries on there, actually, I have determined accounts for 27 heirs, 13 estates, not one of which has been probated. I had recently sent out leases to them like last week, and I've talked to one of the owners today. So it looks like one person on here, it ends up being 27 different heirs and 13 different estates. So we continue to try to find all of these people if we can, and continue to try to get them leased. I even sent out a lease this morning for somebody else. So we're working on that, and in this particular case, we have got 98.43114% of the working interest owners signed up, plus the Bro Energy, who's elected, which I think, David just explained to you about that. Then in drilling unit 3, we had 9 unleased. We have 5 that are still unleased. However, this is one I sent out this morning. I sent out a lease to this woman this morning. And then I have identified the heirs of Dolly Shields, Lana Shields, and Fiona and William Perry. So I'm working on all that too. I just haven't gotten anything back from any of them or any response from any of them. So we're leaving those on. And since none of these estates have been probated, I mean, one family has 13 estates, but not any probated. So I'm relying on families to tell me who the heirs are, and that just doesn't really legally transfer title. So we're working on trying to get this all cleaned up as best we can, and hopefully we can get it done soon.
Okay. Thank you.
Sure.
Let's turn now to amended Exhibit 1 and 2 and second amended Exhibit 3 and then Exhibits 4 through 6. Let's have you please explain what these exhibits are.
Okay, so from the title opinion, we find out who has leased already and who has not leased, or who is a working interest owner, and then, you know, we set these people out with whether they're working interest or an unleased interest, and then, you know, we send out, this is interesting, we send out letters, offer letters to working interest owners and to unleased mineral interest owners. And one of the things I've found interesting is if I get one back that says it's unclaimed, I will remail it without a certified, because they just don't want to go down to the post office and sign for it. So I have sometimes been able to contact some of these people as long as I don't send it certified, but I always send it certified the first time around. And so each one of these, we keep track of where we mailed it, when we mailed it. We keep track of the green cards when they come back, if they come back, or if they come back undeliverable, then I will sit down and do the best I can to try to find them through the internet or through other resources that we've got, Ancestry.com. I mean, there's quite a few resources that we use to try to find a valid address, or even somebody who might know them. And if we are able to find someone who knows them and has a better address, we'll send it again out to that address. That's why sometimes you'll see offer sent again, and send again. But we do try really hard to locate as many of these people as we possibly can.
Okay. And so amended Exhibits 1 and 2 and second amended Exhibit 3 show the parties sought to be compulsory pooled, correct? Those that
Correct.
are identifiable. And then Exhibits 4 through 6, can you explain what those parties that are listed there on 4 through 6?
Sure. So these are, again, you know, you try to find as many of these heirs as you can, but you rely on family members to tell you who the heirs are. The one family with the 27 heirs and the 13 estates, one of the family members executed affidavits of heirship. Problem is, she didn't understand Utah law of inheritance. And so what happened is she did not recognize a niece that had predeceased her sister. Her niece had children, so under Utah law, her niece's children inherited. She just ignored this niece altogether on a couple of these, and she did it a couple times, on these affidavit heirships. So some of these people ended up not being leased and not being covered by it. So, you know, when you have an old family member that doesn't even doesn't understand the law, that's all it was. A lot of people don't. So not all of the family members, not all the interest owners got leased. And because there was no probate on any of these 13 estates, there's no way for us to know who the heirs are. So we're leaving some of these heirs on these exhibits 4, 5, and 6 to make sure that we cover any heir that we are unaware of, that we may not know about.
Okay. So then exhibits 4, 5, and 6 list the estates of the deceased parties.
Correct.
For which no probate has been conducted yet, correct?
Correct, and for which we are aware of. I think I need to make that clear too. There are some of these unleased interest owners that part of the reason you can't find them is they may be deceased, and I don't know that.
Okay. I'd now like to turn to exhibits O and AI, Leslie, and ask if these were prepared by you or with your input and review.
Yes, they were.
Okay, now can you please explain these two exhibits and the packet of exhibits that these relate to?
Sure. So the first one is the well proposal letter that was sent out by Rick Gallegos of AXIA. And along with the well proposal, he sends an AFE and the proposed joint operating agreement. And we send all of those certified. And then I send out these letters to all the unleased interest owners. For example, Argo Energy here is our sample. So every unleased owner gets one of these letters, and what we're offering to do is we'll lease their minerals, they can sell their minerals, or they're welcome to participate in actually drilling of the well.
Okay, and exhibits O and AI are examples of some other exhibits filed, correct? Can you list what those other exhibits are, or explain that exhibits N through CK?
Correct.
Those contain. That's the complete list of well proposals and lease offers that were sent out, correct?
Correct.
And in the interest of time, instead of going through all 200 of those, we've given just an example of each one: a well proposal to a working interest owner, a lessee, and the other a proposal to lease or participate to a mineral interest owner.
Correct.
And do you recall when these well proposals and offers to lease and participate were sent out?
Yes, the well proposals were sent out February 28th, and the lease proposals were sent out on, it was, hang on just a sec here, January 18th, I believe.
Okay, so it was between January and I believe through April, where some of these were sent out to different parties, correct?
Right, and I'm still sending some of them out.
Okay.
As I identify them.
Okay, and now AXIA has been, as you mentioned, you're still sending out proposals. That's if somebody has reached out to you or you've been able to locate somebody else based on an affidavit of heirship or something like that. So AXIA has been willing to work with and negotiate with those parties interested. However, because of this process, this hearing that we're having today, we have to have a cutoff date as to what parties will be compulsory pooled or not, correct?
Correct.
And AXIA will, as has been done in the past, we'll request sort of a cutoff date between now and the board's regularly scheduled hearing next week to get any additional parties that have leased or participated to submit amended exhibits, removing any additional parties between now and then, and we can, at the end, we can decide if that's appropriate from your perspective. So. Leslie, I want to ask, were these letters sent by certified mail to each of the various parties?
Yes.
And included...
Initially.
Oh, go ahead. Initially, yes. And then the return receipts, those are what are contained within exhibits N through CK for each of those parties, correct?
Correct.
Okay, and I want to point out that for those parties that we could not locate, that we knew either owned an interest or we suspected may own an interest as an heir of a deceased party for an estate that hasn't been done, we asked for and received permission to provide notice by publication, and that will be discussed in the notice portion in just a minute. I'd now like to, we'll move on to the next set of exhibits. First, I want to point out that the Utah Code annotated 40-6-6.5 subsection 6 provides a compulsory pooled unleased owner is entitled to payment of the average landowner's royalty during the payout period. And we'll discuss that with these next exhibits. But first, Leslie, I want to ask if amended exhibits K, L, and M were prepared by you or with your input and review.
Yes, they were.
Okay. Can you please explain these three amended exhibits?
Sure.
Yeah.
So every lease that is out there covering these lands, we know how many net mineral acres that lease covers, the lease royalty, and then we use the calculation here to get a weighted royalty average. So what you'll see, for example, in Exhibit K, is all of the net acres of all the lease interests, which in this particular case amounts to 939.0607 acres within the 1,280 acres. And that end up with the lease royalty and the participation factor, the weighted royalty is a 0.14788,453.
Okay, and to clarify, that's the fee acreage that's leased, correct? Yes.
Correct. This does not include any of like Duchesne County, BIA, BLM, any of the federal or state.
Okay. And then so for Exhibit K, and which is applicable to DU1, drilling unit 1, and the Butcher Butte 23-34H-2-22 well, the average fee landowner's royalty then is this number here on the bottom right of the page I currently have up, correct?
Correct.
The 14.788453.
Right.
Okay. And let's turn to the next amended Exhibit L. And if you can explain which unit this applies to and which well and the average weighted royalty for this well. Okay.
So the amended Exhibit L is for the drilling unit 2, which is the Butcher Butte 27-144 EWH-23 well. And it covers all of the lands and leases that we have leased currently today, which is 1,175.0703 net acres. You can see each lease's net acres, the lease royalty, and the weighted royalty, which comes to the 18.1864688.1. Or 18, I guess we're doing, if you do it in a percent, 18.646881%.
Okay, and then amended Exhibit M, can you explain the well to which this applies and the average weighted royalty for this well?
Okay, so Exhibit M applies to drilling unit 3, which is for the Butcher Butte, number 35-21 EWH-23 well. And it again covers 1,075.9276 net acres of leases for a total net weighted royalty of 18.423459%.
Okay. Thank you. Okay, we'll now turn to the JOA, which was submitted as Exhibit G. Leslie, was this prepared by you or AXIA personnel with your input and review?
Rick actually prepared this, but yeah.
Okay, but you have reviewed this exhibit and
yes.
Yeah, okay. Okay, can you explain what this exhibit is, and then we'll point out a few of the relevant portions for everybody here.
Yeah, why don't you? I think I'm going to have Rick address is.
Okay, but before Rick testifies, I'd like him to state his name and business address for the record.
Sure. Rick Gallegos, 1805 Shea Center Drive, Suite 400, Highlands Ranch, Colorado, 80129.
Okay, and your position with AXIA?
I'm the Vice President of Land.
Okay. Rick, Leslie mentioned that this exhibit was prepared by you. Is that correct?
That is correct.
Okay. Can you please explain this exhibit?
Sure. This is the joint operating agreement here that covers operations that the bulk of all the working interest owners signed. As mentioned earlier, there's a couple of them that did not sign it, and it will be imposed under the forced pooling order. But typically, we had about 95% of the working interest owners did sign this agreement. And what you have here really is it's just the cover page that references the lands that are covered, and then Exhibit C, which governs the accounting procedure, all expenses and revenues.
Okay. Let's go to this page, what is page 11 of the JOA, but it's the second slide here for this exhibit. Can you explain the non-consent penalty that we've requested here?
Yes.
Yes,
we are requesting a 100% / 300% non-consent penalty here today. The working interest owners that have signed the JOA have agreed to a 400% non-consent penalty.
Okay. And is it your experience in Utah that the 400% is a commonly accepted risk penalty by industry partners?
Yes.
Okay, but to clarify, we're asking for the 300% only, correct?
That the lesser amount. That is correct.
Okay. Utah Code Annotated 40-6-6.5, subsection 4D3 provides that the board may impose a reasonable interest charge. As Rick mentioned, Exhibit C to the JOA is the COPUS, and page 3 of that COPUS, which we have up on the screen now, shows the interest rate which is requested or which is put into the JOA. Rick, can you explain what that shows there up on the screen?
Yeah, it's the rate that's set by the Wall Street Journal plus 3%, and we feel this to be fair compensation.
Okay. And this encourages timely payment of chargeable costs and expenses, correct?
That's correct, and it's common amongst the operators.
Okay. Now, page C9 of that COPUS, the JOA exhibit. Can you explain what's on this page?
Yeah, what that sets out is the drilling and producing overhead rates. And we have drilling overhead charges of $10,000 a month, and then $1,000 for a producing well rate, which is actually lower than most of the operators that are drilling horizontals in this area.
Okay, thank you. One question, are these costs and charges typical for other JOAs in the area and included in JOAs signed between AXIA and other non-operating working interest owners?
Yes, they're very typical for operators in the area, and actually maybe even a little lower than some operators I've seen for a typical type horizontal well.
Okay, thank you. I'd like to go back to Leslie now so we can discuss the notice portion of this request. Now, Leslie, I believe you have in front of you a certificate of mailing. Is that correct?
Yes, I do.
Okay, and this is a pleading that was prepared by Leslie and AXIA personnel, and it's already on file in this cause. I'm not putting it up on the board, but Leslie, do you recognize the names on that list?
Yes, I do.
Okay, and who are those those individuals or entities?
These consist of all of the non-consenting working interest owners who didn't sign a joint operating agreement, unleased interests, and it also includes the government agencies, Duchesne County, the BIA, the state of Utah, University Lands, BLM.
Okay, and does it also include other working interest owners, lessees, whether they consented or not?
Yes, we do have the consenting working interest owners on this list as well that we have removed because they've signed the joint operating agreement. So they're not being pooled.
And were these addresses for those locatable parties derived from title opinions prepared by the title examiners and updated by you prior to this, the filing of this request?
Yes.
Okay. We'll turn now to Exhibit ZZZ. And Leslie, can you explain what this exhibit is?
Yes, this is showing you all of the certified return receipt requests that we sent out to all of the people that were listed under the certificate of service, and those were all mailed out on May 17th, 2018.
Okay, and so this was, to clarify, this is for a copy of the request that was sent to all the locatable, identifiable parties, correct?
Correct.
Okay, and rather than going through each page of this exhibit, we've just pulled a couple pages just to show, because I believe the full Exhibit ZZZ is 85 pages. So, so we're not going to put them all up on the screen right now, but there are a couple pages here. Okay, now as to the unlocatable parties, what did you do to try to locate those parties? What did your searches include?
Well, it includes just a regular Google search, and then there are about 3 or 4 different like white pages, and then one that we have a subscription to that's supposed to be a little bit more advanced. I check Ancestry.com. Sometimes if I recognize another name and I realize they're related to each other, I'll contact their siblings. And honestly, this publication is how we got in touch with one of the unleased owners. They saw their name in there and called. So the publication is another resource in which we can use to locate some of these people that are hard to find.
Okay, and so, so as to the identified unlocatable owners and the unknowns, I want to just point out that you stated that the investigation included general internet searches like Google and white pages, Ancestry.com. Is that correct? Okay.
Yeah.
And then for those that ultimately you couldn't find a valid address for, we filed a motion with the board to provide notice by publication, and that was granted, and that's what this Exhibit YYY shows. Can you briefly explain this exhibit here, Leslie?
So this shows everyone that we were unable to locate from a bad address or an unknown address altogether, and listed all of those names within this publication. And it was certified that it had gotten published in the Uinta Basin Standard for 2 consecutive issues, first published on the 29th of May, and then again on June 5th.
Okay, thank you. And then again, to reiterate, this was an AXIA's amended ex parte motion for service by publication, which was filed on May 11th, 2018. The order was granted by the board, and its order dated May 21st, 2018, and then thereafter it was published in the Uinta Basin Standard. Mr. Rogers, this concludes my examination of Ms. Gadd and Mr. Gallegos.
Okay. Division, do you have cross for them?
I do, not a ton, but a couple of questions. I think really only, at least from me, for Ms. Gadd. So I apologize, I'm probably going to skip around a little bit here, trying to keep everything organized, but okay, so I guess starting with those amended exhibits 1 and 2 and second amended exhibit 3. One question that I had on those is that some of those parties are listed as possibly unlocatable, and then other times it just says unlocatable. And if you could just explain the distinction between that for me.
Well, if you look at Exhibit 1, American Pioneer, for example, you know, they were sent a joint operating agreement and a well proposal to participate. And I believe we consider this possibly unlocatable because we haven't received the package back, nor have we received the green card. So we're just not sure. We're certainly going to continue to try to find some of these people. Then when it's returned to us with a bad address, they are definitely unlocatable. When it comes back with a bad address, again, we get on the internet, Google searches, white pages, people search, ancestry wouldn't apply to a working interest owner because these are companies, not individuals. But we do actually try, and sometimes we'll send things out 3-4 times before and they all come back as not at this address, moved 20 years ago. So the possibly locatable just simply means we have gotten nothing back. We haven't gotten our green card back, and we haven't gotten the envelope back. So we don't even really know where it is.
Okay, thank you. And then just a couple follow-up questions on, we've talked a lot about heirs, and I think your counsel kind of outlined this a little bit in his introduction, but could you just clarify how that works when there hasn't been probate done? So you have a lease signed with someone who you think is their heir, but you can't say for sure because there's no probate, and then do you just kind of hold whatever you would pay them under that lease and then pay them once probate is done? Is that
correct?
Okay.
Correct. You know, I mean, you know, there's something to be said about family members knowing who their relatives are. So we will take leases from those parties. But like I explained before, there was one where, because she didn't understand Utah law, she didn't mention 2 nieces who had predeceased or who have died since their parents died. And so because they're deceased, she didn't recognize them. And Utah law does recognize them. So those affidavit heirships cannot be relied upon 100%. You really do have to go through these probates to determine who has the right to inherit under Utah law. So yes, we take leases from the parties that we believe to be heirs, and one of our requirements is they need to go through probate to make sure that they are the rightful owner of that interest before we'll disperse money to them.
Okay, thank you. Okay, I think that's all I have for these exhibits, and then just a couple of questions with respect to the offer letters.
Okay.
I want to touch a little bit on timing for those. Can you talk about when the offer letters were sent out relative to, which I think you did mention, but then relative to when each well was spud, just the time between those two events.
You know, we try to always get these out as soon as we can get a title opinion, from our title attorneys. So and sometimes we will actually get the title attorney to give us the list of the working interest owners and their interests, and a list of the unleased mineral interest owners and their interests prior to them actually issuing their final title opinion. The minute we receive that, we get on getting well proposals out and leases out to those unleased owners. We do everything we can to make sure that we're at least 30 to 60 days ahead of a spud date on those proposals. So they have plenty of time to look that over and review all the paperwork that is sent to them.
So specific to this case, did that happen?
I believe so. I believe we did get most of all this out in a timely manner.
We always try to ensure, and I guess we do ensure, that we have the letters out 30 days before we file a forced pooling order, that the working interest owner and the unleased owners have notice 30 days prior to us filing an application. Now, it may not be 30 days prior to spudding a well. That varies, that timing varies, but it certainly, we get it out in 30 days before we file our application. So they have plenty of time in which to make an election.
Before you file this, your forced pooling?
That's
request,
correct.
Okay. Can you just, and I apologize if it's already been said or if it's in this pile of papers someplace, can you just give me the 3 spud dates for these wells?
Erin, do you have them off the top of your head? I can go get them. I don't believe I have them.
We don't. It's the 2 east-west wells, and then it's 14 and 23 and 2 south, 2 west.
So next pad? Next pad will be in 2 weeks.
Oh, no.
No. She wants the actual spud date of each one of these 3 wells.
Yeah.
Okay, I don't have that.
Yeah, we don't.
Do you want me to go get them? I can.
I think that we have them, but I'm asking the question because it appears that one of these wells at least was spud in 2017, and it also appears that these offer letters went out all in 2018. So that's kind of what I'm after here.
Yeah, if I can speak to this here. So for purposes of a compulsory pooling order, you have to give the mineral interest owner or working interest owner or lessees 30 days to respond to your proposal to lease or offer to participate prior to having their interest compulsory pooled. And so to Rick's point, what he's saying is that we made sure these letters went out at least 30 days prior to filing the request, so we meet that deadline. That's the only deadline that matters. It doesn't matter how much time before you spud the well they go out for purposes of compulsory pooling requests.
Yes, I understand that, but I thought that Ms. Gadd's testimony was that they always try to get these out 30 to 60 days before a spud date. So that testimony seemed contrary to what
Rick corrected her and said 30 to 60 days prior to the filing of the request, I believe. Was that correct, Rick? Was that what you were?
That is correct. And we have, none of these wells spud in 2017. The first well that we drilled was the one in sections 1423 and 22, and that didn't spud with a well capable of drilling to total depth until the end of February of 18. And that was the first of the 3 wells drilled.
Okay, thank you. Okay, I just had one last sort of timing thing, which I think is likely a typo, but I just would like to clarify it for the record. So if we turn to, I believe it's amended Exhibit 2, there's a few folks in there that are listing the election offer mailed on 4/5/13. Is that 4/5/18?
Yes, that's a typo.
Okay.
Yeah, we're not that far ahead.
Okay. Just so it's clear on the record. Okay. Thank you. And then one more question on the offer letter to the offer to participate letter. In that letter, I believe it says you must sign an operating agreement in order to participate. And then it seems that a couple of the parties that are going to participate are not going to be signing an operating agreement. Is that correct?
That is correct.
Okay, so I guess maybe that's just a thing to clarify in future offer letters, is that that's actually, you don't...
Well, we're certainly saying that you must sign it in order to participate and not be under the forced pooling application. That is correct.
Okay. And I guess a hypothetical, if the board didn't want to impose a JOA, what would AXIA's plan of attack be? If the board said, we're not going to impose that JOA, and also we're not going to force pool someone who says they want to participate. I guess how would we handle that?
How, if you didn't force pool someone that did not participate, then we would carry them at 100%.
Well, I think that they are agreeing to participate, right, but not agreeing to sign a JOA. And so AXIA is asking the board to impose a JOA. And I assume the board will do that, but I'm just kind of trying to flesh out, if the board decides it doesn't want to impose a JOA, then would AXIA revert back to asking them to be force pooled, or would AXIA allow them to participate without a JOA?
Under that scenario, if they have elected to participate, so we wouldn't ask them to be force pooled because they've elected to participate. And then they would still be responsible for their share of expenses and entitled to their share of revenues at that point. But they would not be entitled to some of the benefits that come through the JOA. So in essence, we would still probably treat them as if they were under a JOA because they got to pay their bills and they're entitled to their revenues.
So we have
what we wouldn't have to, though, is we would not be obligated in any way to market their gas for them. So that would be to their disadvantage. That's correct.
Yeah, so I haven't discussed with my client sort of what the legal options are of if for some reason the JOA wasn't imposed upon them. I believe that the rules would allow, that the rules do allow us to propose a JOA and ask that it be imposed upon them. The other party would also be, they're permitted under the rules to propose their own JOA, and then we would do that in front of the board hearing. But the real crux behind having a JOA is to govern the operations between the two parties, so you know who's responsible for what and how you have to account to them and what they're responsible for, and so that's why it's definitely preferable to have a JOA imposed upon the parties.
I understand that. I know the statute is a may, so the board is not really obligated to do that, and I guess I just thought I was curious how AXIA would like to approach it if the board elects not to do that.
Yeah, I think we'd have to discuss some more what exactly those options would be and best course.
Okay. Okay, thank you. No further questions from the division.
Next witness?
You don't have any questions?
No, I'm fine.
Okay.
I'll say at this time, though, I'm a little uneasy about going forth with this without the board's input on how they want to handle that JOA. And so I think that's something as we get towards the end of this, we can consider that. And I will probably bring it up again, but maybe the order we determined might have to address that issue and have the board decide on that. That's
Okay.
what I'm thinking right now.
Okay. Okay, I would now like to call my next witness, Mr. Taryn Frenzel. This exhibit up. Mr. Frenzel has previously been recognized as an expert in petroleum engineering and various spacing and compulsory pooling requests, including most recently in docket 2017-029, cause number 139-152. His statement of qualifications are up here on the board. Again, based on that statement of qualifications and the stipulation of the division and in accordance with the previous practice of having him admitted as an expert in engineering, I would ask that he be recognized as an expert in petroleum engineering for purposes of this cause.
Division, do you have any questions or issues with that?
No objections.
Yeah, thank you. So accepted.
Okay. Taryn, can you please state your name and business address for the record?
Taryn Frenzel, Highlands Ranch, Colorado.
And your current position with AXIA?
VP of Completions and Engineering.
Okay, thank you. I believe in front of you, you have exhibits H, I, and J. Is that correct?
Yep.
Okay, and were these prepared by you or AXIA personnel with your input and review?
Yes.
Okay, just getting to the first exhibit now. Okay, can you please explain these exhibits, and because they're all similar, we'll kind of, you can hit them all, exhibit H, I, and J.
Yes, these are the drill and complete costs for each of these wells on H. Drilling unit 1, thank you, is $11.46 million to drill and complete. I is $10.7 million in drilling unit 2, and J is in drilling unit 3 is $10.98 million to drill and complete that well.
Okay, and the second page of each of those exhibits, can you explain what's on those pages there?
That's the cost to reclaim each pad and plug and abandon each well, $197,000 each.
Okay. In your expert opinion, are these costs that you listed here fair, reasonable, and necessary?
They are.
Okay. Now, in one of the Exhibit G, the JOA exhibit, we discuss a risk compensation penalty where we've requested 30 or 300%. Can you discuss the risks associated with drilling these 3 wells, sort of in light of justification of the risk penalty that we've requested?
Sure. These are 2-mile laterals, 22,000 feet long. That imposes risks every day. It's a long ways down there to be working with tools. Any small problem becomes a large problem. On top of that, we have very high pressure, 0.82 to 0.85 reservoir pressure. So that just adds to the risk. Again, any problem that you may have is exacerbated by the pressure. And then we're doing 5 different zones in all areas of 3 townships. So everything changes as soon as you get used to one thing, something changes on us.
Okay. In your expert opinion, especially when considering the amount of risk involved, and for the other reasons outlined, by Leslie, is the 300% non-consent penalty justified?
Yes.
Okay. So that concludes my examination of Mr. Frenzel.
Okay. Division?
We don't have any questions for this witness.
Okay. Does that conclude your witness?
So, yeah, so that concludes my presentation in chief. At whatever point you would like me to, I'd move for admission of the exhibits and just to make some final remarks, so however you'd like to proceed.
Okay. Division, do you have anything to bring forward?
Sure. Yeah, I have some final remarks. I don't know if we want to do that before or after exhibits. Doesn't matter to us.
Yeah, either way.
Okay, I'll just go ahead then. I guess I would echo your concerns, Mr. Rogers, about the imposition of the JOA. I do think it's not something that the board routinely does, and although they do have the power to do so, it's discretionary. And I will note that this is a JOA or substantially similar to a JOA that the board has imposed before, but I do think that case was distinct from this case in that it was sort of a hotly contested issue. We did have another party proposing a different JOA, and it was sort of a place where the board was more pushed to actually select and impose a JOA. So I do have the same concerns, just in the sense that it's not something that's really done often, and I don't think that these hearing examiner meetings are typically a appropriate venue for doing novel things. The other sort of just outlying issues would be the publication deadlines and the deadlines for parties to sign up. And I just note those as things that we should resolve while we're all sitting here today. So we need a deadline for parties who are still thinking about signing up or that AXIA is still trying to work with. And then we need to make sure those publication timeframes have all run. Aside from those issues, the division supports AXIA's request and is, generally impressed by their efforts to locate these folks. It's clear that they've really gone out of their way and above and beyond in their location and due process efforts. So that's definitely notable.
Okay,
Thanks.
you. Yes, Mr. Bull, I would like to set a deadline of when you would finalize, except that anyone else trying to participate in this well. The hearing date is the 27th, correct?
Yeah.
So, I mean, there's not a lot of time to work in there.
Right. So if, in order to prepare, proposed findings of fact and to have all of that in, let me grab a calendar here real quick. I believe I would probably need everything by Monday the 25th. I could have it prepared, but and then if there's a change, it would be easier if I knew by the 22nd. And because AXIA doesn't work on Saturday and Sunday, it may just make more sense to make Friday, June 22nd, the cutoff, which will give me time to prepare everything for a proposed hearing examiners.
Yeah, I think the 25th would be cutting it close because we'll be traveling Tuesday and Wednesday. We'll be down, and I just think if there was something we had issue with, it would pose a problem. So I'm proposing Friday the 22nd. Would that be acceptable to you?
Yep, that sounds good.
Okay.
Yeah.
And then as far as,
Sorry, that, just to follow up on that, is
Okay.
that's also, I guess, what we're saying would be when we would need the proposed findings submitted by, is that?
You're saying that you would need them submitted by this Friday? 2 days?
Well, with us being out on Tuesday and Wednesday, I mean, I guess first thing Monday.
Yeah.
But not late in the day Monday.
Yeah, I think I could
So
have
we
it
have
prepared for
time
you
to
early Monday.
Look those over.
Yeah,
kind of ruins your weekend?
a little bit.
Sorry.
And I would, and this is kind of unique in a hearing examiner's position, but I am uneasy about the JOA, and I'm not sure how to handle this, because I think it's something that the board most likely should decide rather than in my position here. How could we handle that such that we could accept it to that point, but then allow the board to hear that?
Yeah, I think that the proposed findings of fact could be drafted in a way that lists the points of agreement here, and then has a separate provision that the petitioner is requested that the JOA be imposed upon those parties, which is the Bro Energy, the International Petroleum, different iterations, and that if that's, and that possibly that you're leaving that for the board to decide because you don't feel that it's, you don't feel comfortable making that decision. However, I want to make a point of clarification to something that Meg said, that she said it's unusual that a JOA is imposed upon the parties, and it's, I think we need to maybe separate out two distinct situations, because every compulsory pooling request we do, we submit a JOA, and all the orders say that the terms of that JOA are imposed upon the non-consenting owners and to govern the operations between the operator and the non-consenting owners. I think what you may be referring to as unique in this situation is where one of these parties has agreed and elected to participate, but has not signed the JOA and has agreed that this JOA can be imposed upon them. Now, I understand in the example that you gave where there were two parties proposing different JOAs and the board had to make a decision and wasn't very comfortable with it. Here, this other party who we're asking the JOA be imposed upon has not filed anything. They're not proposing a different JOA. And again, with agreement with their counsel, they understand that that's what we're requesting and that they've accepted. So it's not where we're fighting over provisions of a JOA or two different JOAs. It's we're asking that it be imposed upon them because, again, under the rules, they could come and submit, their own proposed JOA. We would submit ours, and it would be a hearing, and we could do that. But where they haven't objected and they're not proposing anything else, I don't think it's a complicated situation, at least for where the hearing examiner could recommend, because they haven't filed anything. It's part of what we're requesting, that you recommend it, but it's up to the board to decide if they're going to impose these terms or not.
Well, I'll probably hold off on my recommendation. I think I will present it before the board briefly and allow them decision to make that at
Okay.
this time, and we'll see where they go with that. I mean, I'm not sure if you're planning on being down there. I don't think you were, as you indicated earlier.
Yeah, I hadn't planned on it, but if I have to be, I will be there.
But I think that's where I need to head with this right now.
Okay, and I'll discuss that with my client if I need to be down there.
I just one more thing on that is good clarification, but I do think the board will not take imposing a JOA lightly.
Sure.
Just my kind of guess. So maybe
Okay.
going would be not the worst idea.
Sure.
Yeah, I know the whole process of having a hearing examiner to try to avoid a board process, but in this case, I think it may be necessary to present the idea before them. I don't think it will take a long process, but I think it's something they don't have to go through everything again, but I think we can just let that item be out there.
Sure. And it would be much easier if it was here. It's just the trip to
Yeah.
Delta, but that's okay.
Yeah, it would be. Anything? Well, let's go ahead with admission of exhibits then.
Yeah, so I would like to move for admission of the exhibits, and I'll go through what I've got. If you guys have something different, we can discuss it. It would be move for admission of amended exhibits 1 and 2, and second amended exhibit 3, exhibits 4 through 9, and those are all exhibits to the request. And then exhibits A through J, amended exhibits K, L, and M, exhibits N through CK.
Wait, hold on, what was that again?
Exhibits N through CK.
Okay.
And then exhibits Y, 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 and Z, Z, Z.
Julianne, did you get those? Okay, thank you. Okay, we will accept those as exhibits.
Okay.
Any concluding remarks?
Just that I believe that the statutory and regulatory requirements have been satisfied and for the granting of this request, and that the relief is fair, reasonable, and justified, and we ask that it be adopted and approved, recommended by you for approval to the board.
Okay. Could you then get your, prepare the findings of fact with that one caveat of what we'll hold out on the approval of the joint operating agreement, and we'll look at that. We're looking at that Monday morning, possibly?
Yeah, Monday morning, and I will work with Ms. Whitaker and Meg
Okay.
on some language that we can agree to if we're going to put it off to let the board decide, then we can work through the language there.
Okay, all right. Will you prepare that then?
Yes, I will.
Okay. Well, with that, we'll conclude this hearing, and anywhere else from the division? Okay. All right. Well, thank you. And thank you, those in Denver. Appreciate your preparation and your exhibits, and all went very well. Thank you.
Thank you.